If you or someone you love is on Medicaid and owns a home, there's a rule most people don't hear about until it's too late, and it can affect whether that home stays in the family. It's called Medicaid estate recovery, and it applies in every single state, though the details differ depending on where you live. In the next few minutes, I'm going to walk you through three things. First, why your home isn't actually safe just because Medicaid let you keep it while you were alive. Second, the most common mistake families make when they try to protect the house by transferring it early. And third, a protection built into federal law that a lot of families qualify for and never even ask about. Let's get into it. When you apply for Medicaid to help pay for nursing home care or certain home-based long-term care services, your house is usually treated as an exempt asset. That means it doesn't count against you when Medicaid is deciding if you're eligible. So naturally, people assume that means the house is protected. Period. It's not. That exemption only applies while you're alive. After you pass away, states are federally required to try to recover the money Medicaid spent on your long-term care. And for a lot of families, the home is the only asset left to recover it from. This isn't some obscure loophole. It comes from a federal law passed back in 1993, and it applies to anyone age 55 or older who received long-term care Medicaid, plus, in some cases, younger individuals who were permanently living in a care facility. It's typically triggered after the Medicaid recipient passes away, and the state can file a claim against the estate, most often against the home, since that's usually the biggest asset a retiree has. Now, here's where it gets interesting and where a lot of confusion starts. Not every state defines estate the same way. Some states only go after assets that pass through probate, meaning if your home was already titled to skip probate, through a properly set up trust or the right kind of deed, the state generally can't touch it. Other states use what's called expanded recovery, which can reach much further jointly owned property, payable on death accounts, even certain trusts. So, the honest answer to will Medicaid take my house is, it depends entirely on your state's rules and exactly how that house is titled. That single detail titling is often the difference between a home passing smoothly to your kids or getting tied up in a recovery claim. Someone hears that Medicaid might go after the house later, so they panic and transfer the home to their adult child right away, thinking they're protecting it. Here's the problem. Medicaid has what's called a look-back period, typically 5 years, where they review any transfers of property or assets you made before applying for long-term care coverage. If you gave away the house or sold it for less than it's worth, during that window, it can trigger a penalty period, meaning you become ineligible for Medicaid coverage for a period of time, right when you need the care the most. So, a transfer that was meant to protect the family can actually backfire and leave you without coverage during a health crisis. This is exactly the kind of decision that should never be made without talking to an elder law attorney first, because a well-intentioned deed signed on a kitchen table can create a mess nobody expected. Before we go further, if this kind of information is useful to you, go ahead and hit like and subscribe. I cover these Medicaid and retirement planning topics regularly, and it genuinely helps more retirees find these videos when you do. Now let's get into some of the exceptions, because this is where a lot of families actually get relief they didn't know existed. Federal law requires certain protections regardless of which state you live in. If you have a surviving spouse, the state cannot recover against the home while that spouse is still alive. If you have a minor child or a child of any age who is blind or permanently disabled, the same protection applies. Recovery is delayed, and in many cases, effectively avoided altogether if that child continues living in the home. They're built directly into the law, because Congress didn't want estate recovery to leave a surviving spouse or a vulnerable child without a place to live. If any of these situations apply to your family, that's information worth having in writing, and bringing up the moment Medicaid becomes part of the conversation. There's also something called the caregiver child exemption, and very few people have heard of it. If an adult child lived in the parent's home for at least 2 years before the parent entered a nursing home, and that child provided a level of care that actually delayed the need for institutional care. Some states will allow that home to be transferred to the child without triggering a penalty, and in some cases, it can also help avoid estate recovery later. The catch is, the documentation requirements are strict. You typically need proof of residency, and often some form of documentation showing the caregiving that took place. Families that plan for this ahead of time, rather than trying to piece it together after a parent has already passed, have a much smoother time proving it. Some states can place what's called a Medicaid lien on your home while you're still alive, but only under specific circumstances generally when you're considered permanently institutionalized, meaning you're not expected to return home. Even then, that lien typically can't be enforced while a spouse, minor child, or disabled child is living in the home. A lien is different from estate recovery. Think of it as the state marking its place in line for repayment, rather than actually taking the property immediately. Knowing the difference matters, because a lien notice can feel alarming, but it doesn't automatically mean you're about to lose the house. The timing of when a state can even attempt recovery isn't the same everywhere. And some states have recently extended how long they have, after a death, to file a claim against the estate, meaning families sometimes assume they're in the clear once a certain number of months pass, only to find out their state's window is actually longer than they expected. This is exactly why relying on general internet advice or what worked for a neighbor in a different state can lead you in the wrong direction. Your state's specific deadlines, exemptions, and definition of a state are the details that actually determine the outcome for your family. Now here's the piece I promised you at the start, and it's arguably the most overlooked protection in this entire topic: the undue hardship waiver. Even if none of the automatic exemptions apply to your situation, most states allow families to formally request a waiver of estate recovery if enforcing the claim would cause genuine hardship. This might apply if the home is a family farm that's still the primary income source for an heir, or if selling the home would leave a family member without a place to live and without the means to secure another one. The mistake families make here is assuming this waiver is automatic, or that a caseworker will mention it. It's not automatic, and it's rarely brought up voluntarily. You typically have to formally apply for it, often within a specific window after the state files its claim, and you usually need documentation showing the financial hardship involved. Families who know to ask for this and who apply within the deadline have successfully kept homes in the family that otherwise would have been sold to satisfy a Medicaid claim. If there's one thing to remember from this entire video, it might be this: the protections exist, but almost none of them are automatic. You have to know they're there, and you have to ask. It's also worth mentioning, since this topic tends to attract a lot of rumors, there have been proposals in Congress over the years to roll back or even eliminate the federal estate recovery requirement altogether. As of right now, none of those proposals have become law, so the existing rules remain fully in effect. If that ever changes, it would be a major shift worth knowing about. But for now, families should plan based on the rules as they currently stand, not on legislation that hasn't passed. Your home being exempt while you're alive does not mean it's protected after you pass away. That's the single biggest misunderstanding in this whole topic. Transferring the home in a panic without understanding the look-back period can do more harm than good, and even delay the care you need. And the protections that do exist for spouses, disabled or minor children, caregiver children, and hardship situations are almost never automatic, which means the responsibility falls on you or your family to ask the right questions at the right time. If you take one action away from this video, let it be this: before any property gets transferred, retitled, or signed over to anyone, sit down with an elder law attorney in your specific state and ask directly how estate recovery works, where you live, and whether any of these exemptions apply to your situation. That one conversation, done early, is worth far more than trying to fix a mistake after the fact. Planning ahead isn't about assuming the worst, it's about making sure the choices you've worked your whole life for actually go to the people you intend them for. Take care of yourselves. Take this seriously but not fearfully, and I'll see you in the next one.